Hello, and welcome to this week's edition of Inside Today's Boardrooms presented by Diligent Institute, your source for the latest and greatest in corporate governance, all in 10 minutes. I'm Megan Day, Principal Solution Designer for Diligent, and I'll be your special guest host. Today, I'm joined by Brad Sorrels, Chair of the Governance Litigation Practice at Wilson Sonsini. Brad, thanks for joining us today.
Thank you for having me.
Today, we're going to discuss a topic that we've been getting a lot of questions about from new board members and seasoned directors alike, board communications. Brad, let's start off by having you tell us a little bit about why this is such a crucial topic. And since I'm talking to a lawyer right now, what some of the risks are.
It is important precisely for the risk that you allude to. Litigation is often high stakes, and having your emails or text messages read back in a courtroom setting is never a pleasant experience. But I do like to sort of start with the positive side of it, which is that effective communication is critical to a healthy boardroom dynamic. And directors in particular wear a lot of hats and are often very busy. And so having efficient communication is really important. And so when I advise boards about communication, it's not about less communication. It's about arming directors with the tools and understanding about the ways in which different forms of communication can be used by enterprising plaintiffs' lawyers and how that might play out in litigation.
Some great points there. Do you see any misconceptions about board communications?
Yeah, I think the first one I would start with is privilege. Sort of how attorney-client privilege interacts with board communication. Legal advice, just to start with basics. Privilege only protects legal advice and requests for legal advice. And so merely having a lawyer on an email chain doesn't necessarily protect all of the communications in that chain. At the end of the day, if the communications are fundamentally about business dynamics, those would potentially be discoverable. So I always sort of tell directors, you should start with the assumption that anything you write as a non-lawyer could be discoverable.
That is a very important recommendation. Let's talk about this maybe in action. What are some best practices to stick to?
So I think number one is know the limitations of the medium in which you are communicating. Whether there's sort of a range of potential options, right? From text and Slack and other messaging platforms, all the way to email, all the way to sort of live in-person communication. And, text, for example, it's hard to be nuanced. You don't use punctuation. You oftentimes don't even use complete sentences. And so texts lend themselves in litigation to being interpreted in different ways. And so I always sort of advise folks, text messaging and those similar types of platforms are good for scheduling discussions, sort of very brief, when are we meeting? What are we talking about at this meeting? To the extent you want to have a more formal back and forth, or you want to have some more nuance, email is really better for that because you have to sort of think about your thoughts before you send an email. And then obviously for real back and forth deliberation, live discussions is better, whether that's over the phone or in a live in-person setting. I'd say point two is, and admittedly this is biased, but trust in counsel. Having, whether it be in-house counsel or outside counsel at board meetings can be critical, particularly as you think about the formal board record minutes that come out of a meeting. Trust in your lawyer to sort of, they do this on a regular basis to craft those formal board records, one in a way that accurately reflects the discussion that occurs, but also, summarizes the points in a way that best positions those documents for use later in litigation so that the narrative comes through and you're best protecting yourself when those ultimately get used later. I think point three is, and this is more of a technical point, but think about which email addresses and devices you're using to communicate with. Oftentimes, if you're using a third-party email account for maybe the company where your principal employment is for another board service, that might impact privilege.
Great recommendations, Brad. I think about it from a litigation standpoint, but also think about it from a cyber risk standpoint. You don't necessarily want emails and texts flying around with sensitive information. That's always, standard best practice nowadays. Well, thank you for your time today, Brad. Really appreciate it. As we wrap up, any final thoughts?
Thank you again for having me. I think sort of a parting thought for me is just, and I sort of say this to directors frequently, is just be thoughtful and mindful in your communications. You never really know how, particularly the written word, is going to be used later in litigation. So just being careful and thoughtful as you're crafting your communications is important.
Great tips, Brad. And you can learn more on Wilson Sonsini's website. Thanks for listening, and we'll see you next time.